Discovering or honestly even just suspecting that a vulnerable parent or grandparent is experiencing abuse or severe neglect in a long-term care facility is just a profoundly heavy emotional burden. It is incredibly stressful. But once you make that incredibly difficult decision to actually speak up, families are so often thrown straight into this daunting, complex administrative maze. You want immediate action, naturally, but instead you're faced with layers of bureaucratic processes. So what actually happens after you hit submit on that report?
Well, welcome to this explainer. Today, we're going to completely demystify that administrative maze for you. We're drawing our insights from a really detailed breakdown provided by the Palace Law Firm, who've mapped out the precise regulatory timeline for Indiana long-term care facilities. We're going to walk through exactly what the state does, how long it takes, and what you absolutely need to know to protect your loved ones and your legal rights. Okay, let's dive into this roadmap. We're going to cover this entire chronological journey step by step, starting with filing your formal complaint and navigating the state's triage system. 2, uncovering root causes and the unannounced survey. After that, we'll decode the final report and finish up with taking civil legal action. Ready? Let's get started. All right, Section 1, filing a formal complaint and starting that regulatory clock. The absolute most crucial thing to understand right off the bat is that the state's regulatory clock does not start until an official complaint is successfully filed. How you file matters immensely. Families in Indiana basically have 3 avenues to submit a report to the Indiana Department of Health, or IDOH. You can call their toll-free complaint line, or you can send a written report via traditional mail or email. However, the highly recommended route is Step 1, using the state's online electronic complaint portal. Why? Because it establishes an immediate, trackable digital footprint. When you're dealing with state bureaucracy, having an exact digital timestamp of your submission is literally invaluable.
But here's the catch. Just submitting the form isn't enough. If you submit broad, generalized allegations like, "Hey, the care is poor," your complaint seriously risks being dismissed right at intake. To prevent that, you've got to be highly specific. You need exact dates and shift times, like specifying if the neglect happened on the deep night shift when staffing is at its lowest. You need staff names, or at least physical descriptions and clinical titles like CNA or LPN. Witness contact info is a must, and most importantly, objective physical symptoms. Don't just write, "They're hurt." Provide the precise dimensions of a pressure ulcer, the exact color of unexplained bruising, or documented indicators of rapid weight loss. These concrete clinical details are what force the state to take action.
Moving right along to Section 2, the state's triage system and classifying the threat level.
Once your detailed report is in, you need to know that Indiana doesn't just process them on a first-come, first-served basis. It's strictly a priority-based triage system. State clinical supervisors evaluate the active threat level. The absolute most critical designation is called immediate jeopardy, or IJ. This means the facility's failure has caused or is highly likely to cause serious injury, severe functional impairment, or even death. The source material highlights some truly horrifying examples of this, things like active physical abuse, critical medication errors, or a cognitively impaired resident eloping into freezing temperatures.
That triage designation changes absolutely everything about the state's response time. If a complaint is flagged as immediate jeopardy, federal survey requirements dictate an on-site response within just 3 business days. Super fast. But contrast that intense urgency with high non-immediate jeopardy. This covers really serious issues, like a stage 4 bed sore down to the bone or a hip fracture from a fall, but issues that don't present an active, life-threatening crisis at the exact moment of triage. For those high non-IJ issues, the target on-site response can actually take several weeks, depending entirely on the state's current caseload.
Section 3, uncovering the root cause and the massive impact of understaffing. So why do these severe incidents happen in the first place? Well, the law firm providing our source material offers a very stark professional perspective based on their investigations. They state, almost every instance of severe neglect stems from a single corporate decision, understaffing. When corporate budgets get slashed to maximize profits, nursing and aide staff are reduced to bare minimum levels. This means the direct, hands-on care time per resident just plummets. Unanswered call lights, missed meals, patients lying in bed for hours without being repositioned, unsupervised transfers that lead to dangerous falls. According to the source, if staffing numbers are kept too low, this kind of neglect isn't some random accident. It's practically an inevitability.
Okay, Section 4, the unannounced state survey and forensic evidence collection.
All right, so your complaint has cleared triage and it's time for action. An IDOH state health surveyor is dispatched directly to the facility. Their greatest weapon, the complete element of surprise. By law, the nursing home receives absolutely zero advanced warning.
Tipping them off is a severe violation. This ensures the facility can't just temporarily bring in emergency staff, clean up neglected units, or alter paper records before the state walks in. Once inside, the investigator essentially acts as a forensic auditor. They're auditing electronic medical records, medication logs, treatment charts. They conduct confidential interviews with floor staff, directors, and the residents themselves. And they directly observe care, like wound treatments and meal distributions, to see what's actually happening on the floor in real time.
Let's move to and see how this builds out on a timeline, because here is the harsh reality of the administrative process. Day 0 is when you officially file. Between days 7 and 10, the IDOH sends you an initial validation confirming receipt. But, looking down at the end of the timeline, the overall investigation, from the first on-site visit to the final approval of the file, routinely takes between 90 and 120 days for a standard complaint. Systemic backlogs and surveyor shortages can unfortunately stretch this out to 4 long months.
Section 5. Decoding the final report. Specifically, the CMS Form 2567.
So, after those 120 days, the state finally concludes its active investigation and generates the official public-facing record. This document is known as the CMS Form 2567. State deficiencies found during the survey are plotted on this federal scope and severity grid. The grid ranges from A, which means isolated minor issues, all the way up to L, which signifies widespread, immediate jeopardy. So the absolutely crucial point here is this. If the state issues a citation of category G or higher on this grid, it officially indicates that actual harm has occurred to a resident. As you can imagine, having that state confirmation is incredibly valuable evidence.
Now, if the state does issue citations on that form, the facility cannot just brush them off. Within 10 days, the nursing home is legally required to submit a formal plan of correction. This plan has to detail exactly how they corrected that specific deficiency, how they're going to identify other residents who might be at risk, what systemic changes in staff retraining they are implementing, and how they plan to internally monitor their own performance to make sure it doesn't happen again.
And finally, Section 6, taking civil legal action and understanding state action versus civil lawsuits.
Now, what's really interesting about this slide is how clearly it separates two paths that families often confuse. It's so easy to mix up filing a state complaint with filing a lawsuit. But look at this split. The IDOH state investigation over on the left is entirely about protecting public safety and penalizing the facility. The state can issue fines, freeze new admissions, or even revoke a license. But they can't give you a dime for what you've been through. A civil lawsuit, on the right side, is a private legal path. Its whole purpose is establishing financial responsibility. This is the only way a family can secure financial compensation to cover medical bills, corrective care, and the human cost of suffering. And remember that official state report we were just talking about? If that report confirms a safety violation occurred, it becomes a massively powerful piece of evidence in your civil lawsuit to prove the facility failed to meet the standard of care.
However, you've got to know that civil suits involving medical-level decisions in Indiana are subject to some really strict rules. If your claim falls under the Indiana Medical Malpractice Act, you actually have to first present it to a medical review panel before you can even step foot in state court. On top of that, for occurrences on or after July 1, 2019, compensation is strictly capped at $1.8 million. This payout is structured so the facility's insurance covers the first $500,000 and a state-managed fund covers the rest up to that cap. But keep in mind, not everything is medical malpractice. Ordinary negligence, like, say, slipping on a wet floor, might not be subject to these exact caps, which is exactly why getting legal expertise is often necessary to categorize your claim correctly.
Another massive legal hurdle you need to be aware of is the timeline. Indiana has a strict 2-year statute of limitations for personal injury and medical malpractice claims. You generally must file your formal civil complaint within exactly 2 years of the date the neglect or abuse actually occurred. Miss that deadline, and your family is permanently barred from seeking justice. The door just closes.
Which really brings us to the final, most urgent reality we want to leave you with today. We know the state investigation can take up to 120 days, right? But nursing home corporations routinely overwrite their digital security footage after just 30 to 60 days. In that time, crucial staff witnesses might quit and move away. Electronic medical record audit trails can mysteriously get lost. So if you wait 4 months just for the state to finish their paperwork, will the critical evidence for your civil case already be gone? This is exactly why early legal advocacy isn't just about rushing to file lawsuits. It's about issuing immediate legal demands to preserve fleeting evidence before it vanishes forever.
Thank you so much for joining us on this explainer. We really hope this breakdown has empowered you with a much clearer understanding of what is undeniably a very complex system.